is Alex Fisher. I am the chairperson designee of the New York City Loft Board. I would like to welcome you to our February 18th, 2016 public meeting. We have from the fire department here, Joseph Gregory in place of Chief Spadafora. Welcome.
Thank you.
So first we turn to a vote on the minutes from the January 21st, 2016 public meeting. Does anyone have any corrections or comments on the minutes? No. Is there a motion to accept the minutes? Michelle, thank you. Mr. Delaney, second.
Mr. Barrett,
Yes.
Mr. Gregory,
Abstain.
Chairperson
Accept.
Delaney,
Yes.
Ms. Golden Rivera,
Yes.
Mr. Sheck,
Yes.
Mr. Sutton.
Yes.
6 in favor, 1 abstain.
Thank you. Lanny Alexander, our executive director, will now give her report.
Good afternoon, everyone. First, I'd just like to make a note about this room. We do have it, I believe, for the remainder of the year, although things are fast disappearing little by little. But we do have to be out by 4:45 because they closed the building now that there's no city planning upstairs. So we just keep that in mind for our, we've been going rather quickly, but just when we get into some other things. So first of all, at the last meeting, Mr. Delaney had asked the staff if we could provide a summary of the recent extension applications filed and their outcome. So I made you a list of all of the extension applications that were filed for the year 2015 and their outcome. We had 22 of them. Of these, 6 were granted. Of these 6, 4 were new owners, and one was a new IMD unit, or new IMD building, so that came in under the exception. And then one which was not a new owner, a new IMD, which fulfilled the statutory requirement of good faith and problems beyond the conditions beyond the owner's control. There were 16 that were denied. Of these, 10 were time barred. 2 of them had defective service on the tenants, and actually one of those was also time barred. And 4 were denied for failing to meet the statutory conditions of good faith and conditions beyond the owner's control. So that's the outcome of the 22 extension applications, most of which you don't see because they're not appealed. Do you have any questions about this?
Sure, thank you very much. Do you happen to know off the top of your head what the conditions beyond the owner's control were at 329 Greenwich?
Let's see if I can read it. Tenants, this was the one with the issue of whether the top floor was 1 unit or 2, and that had been in litigation for quite some time. So nobody knew whether they would legalize the unit as 1 or 2 until we had delivered our final order. Once that was done, the owner commenced their work on getting ready to do the legalization, and we gave them the extension as not being within its control.
Okay, thank you.
Okay? Now, my other news of the day is that I'm pleased to announce to you that the mayor has appointed a new owner's representative. His name is Robert Carver. A little about Mr. Carver. He is a real estate attorney with 24 years of experience, working both in the private and public sector. This gives him a unique perspective, which will be especially helpful to us in working through the issues presented to the Loft Board. In the private sector, he spent the last 15 years representing owners and lenders in real estate conveyances and financing, and in the appeal of property tax assessments, including interpreting and explaining aspects of the loft law when necessary. Excuse me. In the public sector, he spent 7 years as an assistant corporation counsel at the New York City Law Department. Additionally, he spent the last 12 years as a board member holding the real estate seat on the New York City Environmental Control Board. In that capacity, in particular, he interacted with enforcement personnel of the Buildings Department and the Fire Department, and reviewed and approved the appeals to the board of the decisions of hearing officers interpreting the rules and code governing buildings and fire cases, as well as cases of other city agencies. In that capacity, he has gained knowledge of the various laws that come into play during the lawful cases that will serve him well during his tenure as a board member. He's also a director of the Real Estate Tax Review Bar Association and is on the board of directors of his cooperative housing corporation. So I would like to present to you Mr. Carver, who has graciously agreed to come today and witness what we do. And we will welcome you next March as the newest member of the law board. So that is Mr. Carver. And that's my report.
Thank you, Ms. Alexander.
Yeah, I'm sorry, I do have one question, which is, yesterday it was brought to my attention that there seemed to be some issues that I have not heard of before surrounding certain kinds of heating units in IMD units, particularly Modine heaters, and I wonder if you could kind of give me some update on this.
All right. Modine heaters are generally, as far as I know, Modine heaters are used in factories and commercial buildings. They are not permitted by the Department of Buildings in residential units. And although we are a sort of hybrid, and we attempt not to have to do anything about these Modine heaters prior to the legalization process. In this particular case, and in a case, there was a case before this one, where we had to go to see the unit. I don't remember whether it was heat complaint or what. But when we saw the heaters, we had DOB with us, they vacated the units. These heaters were in the bedrooms, one of them was in a closet. They were considered to be a real safety hazard. So those 2 units, there were 2 units like that, and those 2 units were vacated. And what we did in response to that was they capped the gas, and we worked closely with DOB and with the owner to get new heating arrangements in those units so that the people could get back into their units. Unfortunately, it took several months to do that. In this case, there was some litigation going on between the owner and one of the tenants of one of our buildings. During the course of this litigation, that had nothing to do with us, it was in housing court, a heating issue arose, and the judge ordered the loft board to go and check on the heat. In addition to the fact that we received this order, we also received photographs of the unit. In that photograph, we saw the Modine heater. Now, as a member of the Department of Buildings, as an employee of the Department of Buildings, I should say, it's my responsibility, and also under the law, if there is some sort of safety issue, I'm required to report it to DOB. So we had DOB go out with our inspector. He saw the heater. They called National Grid. National Grid came and cut off the gas to all of the units. Unfortunately, it was just as we hit the coldest weekend of the year. So all of those heaters were turned off. The landlord scrambled to get electric heaters. We were concerned about the electric heaters because the electricity is not up to code. But nevertheless, they received the electric heaters. I can't tell you whether they were heating the entire loft units or what was going on. I can tell you that that was the end of last week. On Tuesday, I believe it was Tuesday, was it Tuesday? It was yesterday. The tenants, the owners, and all of the architects and lawyers came and met with me, and we discussed what we were going to do about this issue. We are having, the landlord is having an electrician come in and look at all of the outlets that are being used with the electric heaters to make sure that they're safe. Meanwhile, we are attempting to get a plan in place for the replacement of the heater, of the heating system, as well as the legalization of the entire building so that everything can be done together. And the owner and the tenants are working closely with their architects to have that done, hopefully by the beginning of next week. It will go then to the plan exam there at the hub. We will ask the plan examiners to expedite this, although it is our feeling that certainly they will not get new heating units in place by the end of the heating season. But they will have those electrical heaters in place. We couldn't get them to pipe in heat from like those trucks that you see sometimes. They don't have that type of piping in the building. So the only alternative was the electric heaters, which they provided. And we have to say, if I have knowledge of one of these heaters in a building that you require me to go to, or one of my people to go to, I have to tell DOB. And they will go and inspect and see if it's safe. I think that the violation that they wrote was that these were heaters that were in the sleeping areas. And that was the violation. So nobody was vacated, it was cold, and that was horrible, but that was what happened. Does that answer your question, Mr. Delaney?
It provides some background. Are people familiar with modine heaters? Basically, it's a unit that has a gas burner exposed in the heater and a blower so that the gas blows out. And there's a kinder, gentler version called the Dynavent, which I believe is legal in residential units, which is a self-contained unit that vents the exhaust from the gas combustion outside the building. It's kind of like an air conditioner with a gas burner. It's a heating unit. The concern is that there are a lot of IMD units, we believe, that still have modine heaters, and this was discussed at great length during the code compliance regulation, and the notion was that those heaters would be replaced, and I believe they have been with those buildings where the landlord has brought the building up to code or chose to bring the building up to code. The problem that we have is with these recalcitrant owners who have not brought the buildings up to code. The danger of the heater, in particular, and I guess the reason it was acceptable in a commercial loft space, is that the product of the combustion of the gas removes oxygen from the atmosphere, and I believe probably creates carbon monoxide. So that in a small space like a bedroom, that could cause the danger of a person dying from carbon monoxide poisoning.
And I believe that's happened in one of the loft buildings.
I believe it happened once,
years.
about 20 years ago, that's correct. And it was a modine heater in a bathroom, and the tenant was in the bathtub, actually, if I recall the specifics. So I guess my first question is when you or a member of your staff look at a unit, is the location of the heater taken into account, or at this moment in time, is it any modine heater going to raise a red flag?
Mr. Delaney, we don't have any, certainly nobody on the staff except for perhaps the inspector who might be able to identify the modine heater. But the inspector is not somebody who would issue a violation or issue a vacate. And generally speaking, let me just say this. Generally speaking, when we get a heating complaint, we don't go out to the unit and take its temperature and issue a violation. What we do, and we have found to be very effective, is we negotiate with the owner to bring heat into the unit. So if something's wrong with the boiler or the furnace, they fix it. Or if it's not set right, they fix it. We work out so that the tenant gets heat. We don't go and see it. There's a reason for it. But if we have to go, we take DOB. We are not the decision maker on these heaters. So I don't know if that answers your question, but we don't do this. DOB does it.
It doesn't, with all due respect.
It's Con Ed that does it.
Well, Con Ed that shuts off the gas.
Yeah.
No, it's the Department of Buildings that makes the determination if it's safe or not. And they make the determination whether it has to be capped, whether it has to be vacated. We always advocate on behalf of the tenants to try to avoid a vacate. And only in the most severe danger do we say, okay, vacate.
Right, okay. The part of my question that is still kind of hanging out there is it your understanding that there is some degree of latitude exercised in finding some Modine heaters, if they're being used in a large open loft space, albeit a residential IMD unit, does that, at this point in time, does that unit lead to a shutoff?
Let me just say this. The first time that I was aware of this type of heater was maybe 5 or 6 years ago, when DOB, for some reason, was in the unit, having nothing to do with us, and reported back to us that there was a Modine heater and it had to be replaced. They issued a violation, they didn't cap it, it wasn't necessary, and they told us that part of the legalization, we needed to make sure that that heater was replaced. It was not acceptable in a residential space. So we worked with the tenant, with the owner, and we had that replaced. The next time it happened was, I believe, last year, when we had the 2 vacates. I have very little understanding or knowledge of the Modine heater. If I understand that it's there, I will contact DOB to inspect. And they will have to make that determination of to what extent they're going to enforce whatever it is. If they see it's dangerous, if it's in the bedroom, they're going to issue a violation, they're going to call Con Ed, they're going to cap it.
If it's in a bedroom.
So I don't know what the extent is. I'm not an inspector for DOB. I cannot answer your question.
Okay, but here's the situation we find ourselves in. All these buildings, with the exception of a couple that have gotten extensions, should have been legalized now. It's not a situation where the tenant can cap his Modine heater and install another heating system. And it would appear that in some of these circumstances, unintentionally, it's the tenant that's kind of paying the price, no heat, and finding himself or herself in kind of a catch-22 situation. I appreciate, as you elaborated, you've been working with the owners to try to find an alternate means of heating. But it would seem to me that if the Modine heater, which in all likelihood the landlord installed many years ago, or a previous landlord installed, is shut off because of a dangerous condition, then that unit is in violation of the minimum housing maintenance standards.
Mr. Delaney, there are many factors that go into whether or not a building is legalized within the time period. There are many times when it is not the owner's fault, and there are many times when it is. However, while it is, you may say, that the tenant is not at fault, it is the tenant that we are concerned with. The owner is not going to die of carbon monoxide poison if he doesn't legalize his building, but the tenant does. And to the extent possible, we have attempted to move all of these owners along.
I'm sure that's true. My question is, when the heat gets capped and there's no heat being supplied to the unit, the owner is then not delivering on the minimum housing maintenance standards. If the loft board were to issue a notice of violation, that would allow the tenant.
We don't have to do that, because when that happens, DOB issues the violation. Right? There's a violation. That's a housing maintenance issue that goes to housing court.
And what violation does the DOB issue?
I don't have it with me, but I'll be happy to let you see.
You know, if we get a good determined answer from somebody from the DOB about this, about the two different gas heaters, because I somehow feel that with that last explosion on 2nd Avenue, the one up in East Harlem, that the law is probably even tougher on all gas heaters. There are alternative electric heaters, you know.
Right.
The so-called ceramic heater uses far less electricity than the old-fashioned ones where you can see it getting red, etc. But I think we need to get a definitive answer from somebody to the department, from an inspector, so we know what we're talking about.
But, exactly, but in that vein, the heat was provided. It wasn't the best heat, but the landlord went out and did what he was responsible to do. He brought in heaters. It's not like he didn't do anything. They immediately went out and tried to fix the problem. They were, you know, they've been really cooperative in working with the tenants to try to provide heat.
But we have not been issuing violations of the minimum housing maintenance standards.
No, because by the time we get finished with negotiating with the landlord, the heating or the violation is gone. Okay? The person gets heat. If the person doesn't get heat, they'll get a violation. They'll write a violation. We always manage to get it is more important for us to get the tenant the heat or the service that they're required to have than it is to just simply write the violation.
Right. I guess and I have no doubt that that's your priority and that you're extremely well intentioned. I guess my question is, in some instances, particularly where you're dealing with highly recalcitrant landlords, it might be beneficial to the tenant to be able to have a violation from the loft board, because everybody knows when it comes to be an IND unit, everyone looks to the loft board, to be able to have an alternate route to pursue, to go to bring an HP action, to have the landlord correct it. I'm sure you're using the tools at your disposal, and if every landlord were persuaded by the tools at the loft board's disposal, a goodly percentage of the buildings that have not yet legalized would be legal, but some of them aren't. So in this case, my concern is that there may be tenants who are incurring additional legal and architectural costs pursuing this approach, who might feel they could have an alternate pathway through an HP proceeding.
All right, and then we send out our inspector and he sees the Modine heater. Would you like me to do that?
Well, the word now is tell people not to file a heating complaint if they have a Modine heater. Suck it up. That's not very good either. That's the catch-22.
Well, and we have nothing in our bylaws that covers this in terms of fines. Is that correct?
Well, if somebody is not getting heat, you know, that's what we work with. But the fact that it's a Modine heater is out of our, that's not a housing maintenance issue. That's a DOB code issue. I mean, we really have nothing to you know, when we were in the mayor's office, we were separate. So that if I wouldn't have even known that there was an issue with the Modine heaters if I had still been in the mayor's office. But because I have sat in the DOB borough commissioner's office for like 4 or 5 years, I'm well aware of many of the safety issues that we have to be mindful
No,
of.
I understand that, and my feeling is that if we were able to levy fines on the landlords for non-compliance to that, then it would force the landlords to move a little quicker. But as far as I know, I've heard of buildings in Soho that have been out of gas for a year and a half, and there's never any fines. It just, everybody has to wait it out until everything gets fixed. And to me, that's really not necessarily acceptable in terms of these IC buildings.
I would just say that with regard to fines, I don't think that Mr. Delaney is really referring to the fine as that would be the thing that would move an owner along,
Well,
because it's not really a significant thing.
That's
What
this
I
is
think
what I
that,
have in mind.
yeah, but I think that what Mr. Delaney is talking about is giving proof to a judge in a housing court proceeding of the violation, the written violation. That would be what you were talking about.
I'm attempting to learn more about this issue, and there have been Modine heaters in these loft buildings for 70, 80 years, forever. And I think we all agree that the recent gas explosions, both in East Harlem and on the Lower East Side, have raised people's sensitivity about gas in buildings. And certainly, I'd rather see a cold tenant than a dead tenant. I'd rather see a building that's not up to code rather than a building that's blown up. But Elliot's right, this has been going on, and for certain owners, the notion that the gas gets shut off and the tenants have no heat, and in some instances no heat or hot water, is just fine with them because they'd really like the tenants to leave. So there runs the danger of kind of backing into becoming a situation where we're in the position of saying, golly, we're trying to work with these owners. And admittedly, they haven't legalized. And, again, kind of then what would motivate the owner? If the tenant withholds rent, will that motivate the owner? If the loft board fines the owner, will that motivate the owner? I don't know, but it would seem to me that if, unlike other conditions, which part of the reason the loft law was passed was to bring these buildings up to code, if Modine heaters or Modine heaters and other gas ignition heaters are kind of becoming a separate issue of concern, then it would be good if we could come up with some way to address that problem. Because the last thing I want to do is have people saying, well, I'm afraid to call the loft board with a heat complaint because they're going to come see my Modine heater and shut off my gas or lock me out.
Well, one of the things that I do say at every narrative statement conference with all of the new buildings that have come in is that I ask that the owners make sure that the gas, if there is gas in it, because of what happened in the Lower East Side and in Harlem, to please check to make sure that the gas is contained, that it's safe, even if it means going into each unit. I don't know what buildings have Modine heaters. I don't ask. Okay? If we get a heat complaint, we work with the owner. We rarely go out. When you want me to send out the inspector, then that's a different story. Then we see what's there. But by and large, we don't see. Yes?
Is there some reason why you can't ask them in the application process? What kind of heat do you provide?
How would we do that in the application process?
What kind of heat does a building have?
Do you want me to be on notice of the heat? First of all, it's not an eligibility criteria, so I don't have any legal reason to ask them what their heat is.
But it's not in the narrative statement.
And
Well,
in the narrative statement, we just see what is going to be replacing whatever is there.
Right, but if the whole purpose of the loft law is to protect tenants, then why wouldn't we want to know that information? It's a safety issue. I'm suggesting it be native criteria or whatever.
We'll have to think about that before we start doing something that, because as Mr. Delaney says, there are a load of buildings that have these heaters.
I know.
What would you do? What would we do if we know that they're there? We have a building that has 75 units, and they all have these. What are we going to do?
Maybe they get prioritized over other applications?
It has nothing to do with priority. Everybody is a priority here. It has to do with the owner timely filing an appropriate narrative statement that is complete, and then the owner and the tenants discussing and coming to an agreement on how the legalization process is going to go in their unit. And that depends on all of them, not just the owner, not just the tenant. And if you want to know what takes time, that's what takes the time, to get everybody to agree. Now, in this particular building, they are practically there already. There were one or two issues that we tried to iron out yesterday, which I think maybe has happened. But by and large, there's nobody here that is blameless in it taking a long time. It is a long and arduous process, unless the owner, unless the building is pretty much already there by the time they come into our jurisdiction, or unless, they're going to do, they're able to legalize these units with minimum amount of work, taking down no walls, and everybody has got the appropriate light and air. Those are rare cases. So we're talking about a process that takes a long time.
Yeah, but could we speed the process up if they knew that there's a risk they're losing their gas heat if they don't?
Well, that was
spend
what
on it?
we contemplated yesterday. Perhaps there's an incentive on both sides to come to some agreement. And maybe that will incentivize all of our owners and tenants to come to an agreement more quickly than they do.
In circumstances that you described, and I know they exist, where there's considerable difference of opinion between the landlord and one or more of the tenants in an IMD building with regard to legalization, does that frequently actually involve the heating unit?
No.
No.
It doesn't involve the heating units at all.
Right.
That's never an issue. The heating units are removed, no question. They are replaced by either baseboard heating or they either have an individual unit put in that is brand new and up to code. Remember, everything has to be up to code. Though we know any heating that's not up to code is not going to stay. So it's either the furnace in the basement that provides heat to everybody, or it's an individual heater, and that is part of the narrative statement, and it's almost never an issue. The only issue would be whether it's going to be gas, if it's going to stay gas, or it's going to be converted to electric. And our position is, if it was gas before, it's going to be gas now, because electricity is more expensive. So that's generally the only dispute.
Our position? No, you don't mean your position.
The loft board's position is you are entitled to the same
Oh.
type of heating that you had when at the effective date of the law. It's a diminishing services type of argument. That then we're not going to let the owner bring in an expensive electrical heater unless the tenant accepts that. But if the tenant doesn't want that, we say, no, that's not what you have to bring in. You have to, if they had gas before, you keep providing gas.
But if that becomes a bone of contention, that's not what's delaying the
That does
process.
not delay
It's
the
other,
process.
it's other things.
Other things. It's roof rights. It's elevators. It's the walls coming down, and I want a skylight. Those are the kinds of issues that usually arise. It's not the electrical. It's not the heat. It's not generally the sprinkler system. It's, oh, you're going to put in risers and you're going to take away some of my space for the upstairs unit. Those are the types of issues that we see.
And that runs the possibility that you have the top floor tenant concerned, let's say, with roof rights.
No, all of them are concerned with roof rights.
Oh.
In some buildings, one building in particular.
Okay, all
They
right.
want to have their recreation space in the roof. And so the issue, that is, and that's a tough issue. Yes, Mr. Schachter.
Yes, please. So I understand that you were just giving out some examples about how complicated the the process can be because of the design issues and the allocations, not only between the tenants and the owner, but perhaps even between tenants. But I want to go back to the question I think that was raised earlier, which is for the Modine heaters, if they represent kind of an immediate exigent health and safety issue, is there a way to sort of address that earlier in the process as a separate component, or and maybe it's just not, it's very either difficult or it's not easily done to kind of decouple that and say, look, this, you're going to be endless discussions about roof rights or whatever, as you gave some examples. But the Modine heaters must really be addressed immediately, even if it's, for example, substituted with an electric heater that is not a permanent substitution, but is a temporary, maybe it's a year or two. I don't know how long the process, but I'm just trying to see whether there's any way to handle it, some things that are health and safety at a different expedited manner, and maybe they're not. I mean, only
Well,
with
I'm not sure how, because I'm not a contractor, I'm not an architect, but maybe common sense, and maybe my common sense is wrong, and that's very, very likely. But it would seem to me that when you are doing structural work in a unit to transfer the heat from this type of heating system to this type of heating system, you want to do that in a coherent way along with the other parts of the legalization process that you're going to do in that unit, right?
Ideally, yes. But,
Ideally.
but
So
if
what
we're
we're talking
about the
about,
idea of the tenants dying that night,
so what we're talking about is
Yes.
is going in and finding, and I don't know whether we put the onus on the owner to inform us that they're Modine heaters, or the tenant, or DOB, or us, and say to all of you who have these heaters, we want to have the gas cut, and we want to put in we want you to put in electrical heaters in the interim while we finish up the legalization conversation. Is that what you're saying?
I'm trying to, if the idea is that this is a hazard that could kill people immediately, then it's, and I completely sympathize with it. It's not that we want to get people kicked out. It's not that we want to evict tenants. It's not that we want to somehow mess with the process, nor do we want to derail the entire complexities of the process. However, if there's an immediate health and safety issue, then I guess it seems to me that this is, and I think that this process, the appeal that we just looked at, it's complicated, it's messy, and you have different owners, you have different participants. It's not, I don't mean to make it sound like, oh, you could just, wave a magic wand and expedite it. So that's, because its very nature is that it's going to be ongoing. If it takes a couple of years, then we're talking about a significant risk, or several years. And so, maybe a thought would be, if you have a Modine heater, you're going to have to, as an owner, then you're going to have to disconnect that, and presumably there's electrical service in the apartment, and then use an appropriate, safe electrical heater. I don't know if this is just a thought, but rather than saying, well, the tenants are going to take their chances.
Yes, Ms. Baldwin-Rivera.
I think, I hear all the complications, but I do think that we have to look at this, because I can see the press that we would have if, in fact, we had one of them blow up. So I think to just say, well, we don't know, it is not necessarily a good result. Considering we are now spending a lot of time talking about it, I think we need to come up with something a little more concrete than we don't know.
I think that what Mr. Barowitz has suggested is really a good idea, and that is that I find out more from DOB about what is and is not acceptable with the Modine heaters. Whether they would permit them to be existent in certain circumstances and not others. And then I will come back to you at our next meeting and I will give you a report on what I find out. How about that?
Well, I agree, but there's this longer issue, is that we're no longer living in the 19th century. And as we know, the landlords have been recalcitrant about getting these buildings up to code. And if it's necessary for them to put a heating unit in the basement or in the roof and pipe it in, then that has to be part of the process of legalizing these buildings. And how much longer can we go on with buildings all over the city that don't have proper heating? This is, you know, we're now in the 21st century, not the 19th. I find it just, you know, it just boggles my mind to think that the landlords, you know, what are they going to do with their buildings if they don't have central heating?
And it may not
What
be
are they
able
going
to
to
be
rent
done.
it to?
Can I just interject one thing, just so that we're clear about something? The two buildings that have had recent issues are both 281-5 buildings. Neither of the owners of those buildings are what I would refer to as recalcitrant owners. These are owners who were timely in their filing, have been cooperative, and to the extent an owner is cooperative, during the narrative statement process. They are not in any way what I would, you know, equal them to the recalcitrant owners that we have in the 281-1 buildings. And I'm not sure, but I think, and maybe you have better insight in this, the Manhattan buildings, do they also have so many of these Modine heaters? The ones that are remaining in our jurisdiction? Do we know?
There were lots of Modine heaters, and you know, just roughly, if we have 300 plus buildings in our universe, a couple of hundred of those are from the original law. So if they have Modine heaters, they've had them now for 30 plus years.
I could tell you that of the 200 and some odd buildings that are left, I think it's 260 something buildings that are left, most of them, if not all of them, have started their legalization. Many of them have legalized and have C of O, TCO, or 7B compliance. The rest of them are still in the process, but they're, you know, they're moving. You know, we only have a few that are still in the narrative statement process. Some come back into the narrative statement process, but they've all had work done in their buildings.
Well, but merely completing the narrow statement process doesn't guarantee that if there's a Modine heater, it's been
and obtained
removed.
permits and have been doing the work and then reporting to us about doing the work. So I'm just saying, it's not like the new buildings where they're just at the beginning of the process, and they are moving much more quickly than the old buildings used to move. I mean, they really, you know, once they're there and they're in, and they do their narrative statement, it moves.
Let's hope that's so. I mean, it's awfully scary with these, you know, we've had a couple of, or one 400 square foot space, or even 550 square foot space. Of course, we don't know what the heating system is. That could be very scary.
I guess my request would be, I think, let me back up a second. It seems implicit in what you said that to a degree, part of the tightrope that you have to walk has been exacerbated by the transfer of the loft board out of the mayor's office into the Department of Buildings. Which, in my mind, I can see how that is, but one would think that city government would be well enough coordinated that that wouldn't be an issue. One would think.
One would think.
But, so in addition, if I understand correctly, you've said that you will get us a report by next month on DOB's position. I guess the other thing that I think would be helpful is maybe if the board staff, not to say for certain that it's feasible, but if they could kind of do a little brainstorming and think outside the box as to whether there would be some way to offer a bifurcated path to code compliance where issues of the electrical supply and the heating supply could be agreed upon and addressed in a
So we
permit.
would give a partial certification for that type of work, is that what you're saying?
Yes.
That's a very excellent idea, and we'll certainly look into that.
And rather than reject it out of hand, I'm sure it would be complicated in some respects, but that, if there's going to be an endless debate over, I used to be able to store my bike in the basement and now I can't, or I want to have planters on the roof, if there are real questions about the electrical supply or the gas supply, it would seem that maybe there might be a way to decouple those that would be to everybody's advantage. Because I'm sure there are buildings where everybody had the roof, but we all have seen a lot of cases where it's just the unit on 6 that has the roof, and everybody else is waiting, and if they're waiting, looking at their Modine heaters while the landlord and the tenant on 6 fight it out, that doesn't seem like a real good
That's
approach.
not
Okay.
Okay. Okay.
We'll come back to that. Thank you. We have one administrative appeal. It is Redbridge Bedford LLC, 156-170 North 4th Street, Brooklyn, AD 0079. Ms. Cruz, please present this case.
Good afternoon, board members. In an administrative determination dated September 25th of 2015, the owner of 156-170 North 4th Street in Brooklyn was denied an extension of the code compliance deadlines based on the untimeliness of the extension application. The owner filed the extension application after the code compliance deadlines had expired. On November 6th of 2015, the owner filed this appeal seeking review of the determination based on the basis that the rule requiring the extension applications to be filed prior to the expiration of the code compliance deadline exceeds the law court's rulemaking authority. The staff recommends that the appeal be denied. In exercising its rulemaking authority, the law court must look to the intent of the statutory language. In enacting MDL 284-1, the legislature established a timetable by which owners must complete the legalization work in their IND buildings. In section 284-17, the legislature gave the law court the authority to grant extensions to the code compliance deadlines to owners who are unable to meet the deadlines for reasons beyond their control, despite their good faith effort to do so. The intent of this statutory language is to establish a time frame for owners to complete the legalization work while providing the law court with the authority to extend these deadlines in certain situations. In September of 2006, the law court added to its rules the requirement to file an extension application prior to the code compliance deadline. And in the statement of basis and purpose, the law court found that there was no acceptable reason for an IND owner to delay in getting an extension. If an owner is in fact engaged in reasonable and necessary action to obtain a certificate of occupancy, then it knows in advance of the code compliance deadline and whether it will meet the deadline. The owner is also aware of what has caused the delays in the legalization work and what obstacles it faced. Requiring that the owner act promptly before it is out of compliance with the legalization timetable is reasonable, rational, and consistent with the legislature's goal to have the owners legalize their IND buildings within a certain time period. A timely extension application is also consistent with the standard that the standard for an extension set forth by the legislature. It is part of the good faith effort to be in compliance with Article 7C. The staff recommends that the appeal be denied.
Thank you. Are there questions or comments about this case? Is there a motion to accept this case? Mr. Barrow, thank you. Do I have a second? Mr. Delaney?
Mr. Barrett?
Yes.
Mr. Gregory?
Yes.
Chairperson?
Yes.
Mr. Delaney?
Yes.
Ms. Golden Rivera?
Yes.
Mr. Schechter?
Yes.
Shelton?
Yes.
Mr. Merkin?
Thank you. We turn next to the summary calendar. So sorry. There are 15 summary cases. These cases are voted on as a group. They are SMCB Associates, LLC, 329 Greenwich Street, LS 0228. 141 Spencer, LLC, 141 Spencer Street, Brooklyn, LS 0229. Aki Adamit, 247-249 West 30th Street, LS 0230. Ethel Kamburian and Mary Grossman, 35 West 19th Street, TN 0223. Mark Parrish, 71 North 7th Street, Brooklyn, TR 0836. Nancy Wong, Carlos Ferraris, Philip Crangy, and Paul Marlowe, 147 West 29th Street, TR 1090. Greg Chan and Michael Ruillard, 57 J Street, Brooklyn, TR 1112. Reed Deland, 57 J Street, Brooklyn, TR 1122. Adrian Cohen, Jay Harrison, Morgan Lang, Tom Soper, and Kiara Diva Pala, 365 West 36th Street, TR 1127. Micah Swazi, 97 Wyckoff Avenue, Brooklyn, TR 1145. Anthony Barker, 97 Wyckoff Avenue, Brooklyn, TR 1166. Sarah Campbell, Kay Christine Nicholson, Sean Pangia, Julie Moskowitz, Orlando Torres, Lane M. Lacola, Stephanie Sugawara, Matt Linder Mulder, Ethan Miller, and Kate Comey, 136-140 Jackson Street, Brooklyn, TR 1201. Moffett Street Holdings LLC, 338 Moffett Street, Brooklyn, TR 1217. 222 Barrett Street Residence, 222-230 Barrett Street, Brooklyn, TR 1222. John Kessel, 207 Star Street, Brooklyn, TR 1270.
I just wanted to explain for the people who are here today that the summary cases are those cases where the applications for whatever they're asking for have been withdrawn, either because of a settlement or for a various number of reasons. But these are cases that are just withdrawn. There's no actual decision on the merits of the case.
Thank you. Other comments or questions, Mr. Delaney?
Yeah, I'm sorry. 15 on the summary count is a big number. I do have questions on a couple of them. Number 4, the access case, 247, 249 West 30th Street. In this case, the tenant and the owner seem to have agreed to a different set of access provisions that are contained in the Loft Board rules. And I know that we, as we often do, say that we neither accept nor reject the terms of the agreement. But my question is, does the tenant have the ability to waive the access provisions set forth in the Loft Board rules, in your opinion?
In my opinion, yes. The tenants have the right to waive it. The Loft Board, in the access case before it, the owner is required then to follow the access requirements. If he's asking board action, then the owner is required to follow the access notice provisions. But if there's something that needs to be done and a tenant is willing to provide the access, and the tenant says, okay, you don't have to send me a notice, we agree, you're coming
Right.
next week, you'll be there for 4 hours, see you later.
Right, I let my landlord has no idea what the access provisions are, probably. And he's an attorney, and he's an attorney. But he and his folks are there all the time, mainly just keeping a TCO alive, which doesn't make a lot of sense. But that's not, my question is, okay, so now a year goes by, and there's another access issue. In our opinion, for us to order the owner to grant access, he has to meet the provisions of the rule. Even if,
Right, but he would have to serve the 2 notices within
Right.
the time period that they're supposed to do it, and he's supposed to explain what work needs to be done, and how long it's going to take, and all of the notices.
so he could not come back, the owner could not come back 2 years from now and say, well, I have an agreement with this tenant, we've got a separate access agreement, and she's violated the agreement that we have. No, okay, fine, good, thank you. Number 7, we've got a case where the owner registered 2 units out of 4 that filed. Looks like I struck a nerve here.
No, we talked about it.
Yeah, and we have 2 units where the tenants have stipulated that they're going to use their units only commercially. and therefore they're not part of the IMD.
Right.
Right. So they're returning to commercial.
Yes,
Use.
that was it.
And there is a provision in the loft law for return to commercial, but this doesn't have anything to do with that. So we've just kind of found another pathway here.
I'm not sure I'm following.
It seems to me that those units are IMD units, and it's up to the 2 units where the tenants say, I'll only use it commercially from now on. And maybe they really mean that. Maybe they don't mean it, and there's a deal made. But in either route, there's nothing in our rules or the law that contemplates this resolution.
That the units will now be registered? I'm not sure I'm following. These units are not registered. The units that were converted back to commercial use are not IMD units. So, I'm not sure I'm following.
They're not IMD units, even though they were,
Well, they weren't, there was no order finding, and there's no registration.
Yeah, okay. So I'm going to vote no on that one. I think we've overstepped our authority in accepting that.
Do you think that we should make a visit and when we get suspicious about a private deal being made?
Oh, I'm sure that will be done anyway. I don't think we need to ask for that.
Okay.
I mean, no, my thinking is that the 2 units that are residential, and we had this come up in a building in Brooklyn where you only asked for these 2 units, so the judge found 5 units qualified for residential use during the window period, but only the 2 units that applied only asked for coverage for themselves. So we found that to be a 2-unit IMD, even though there were 5 units that the oath judge found residentially used. When the time comes for code compliance allocation, that has an effect on the way costs are apportioned. And also, if you believe that the loft law was designed to preserve moderate income housing units, then if the unit was used that way, in my opinion, the owner and the tenant can't erase those tracks and say, oh no, it doesn't, this might look like an IMD unit, it might have been an IMD unit, it might qualify if I wanted it to, I did apply for it, but no, I'm only going to use it commercially going forward.
By the same token, if it had been registered as an IMD unit and the owner bought the person out afterwards and then gave us a declaration of intent to say I'm converting it back to commercial, it would have the same result.
That's the pathway, that's right.
Yeah.
This I don't see a pathway. Okay, next let's take 2 at once, number 8 and number 9. Those are the 2 tenant coverage requests at 57J, which also have 2 cases on the master calendar. Can you just explain the interplay between these and why they weren't consolidated?
Well, they weren't consolidated, one because one was filed by the owner, and the other one was filed by the tenants. The tenants were seeking coverage, and they withdrew their coverage applications in the context of a buyout. And they have left the building. They're no longer there. So it didn't make sense to consolidate the coverage applications, the decoverage applications, which have nothing, as you read in the proposed order. There's no record there. So what we're doing with that is remanding the 2, what's before you today is a proposal to remand the applications back to oath for hearing on that issue. But it didn't make sense to consolidate. The tenants no longer wish to go forward on their applications for coverage and have left the building.
Okay, all right. My last question is on number 14, Moffett Holdings, Moffett Street. The owner filed an application seeking coverage. Prior to the deadline for filing for coverage, your owner's registered the building. Then he registered the buildings after the deadline was reopened. Can you see, and now he's withdrawing his, why didn't he just register? Do we have any idea why we?
No, except that I think that, the registration applications requires owners to provide leases and other information that perhaps he couldn't get together in time, because he filed it on the day of the statute of limitations.
Right.
So he probably didn't have all the information handy and filed it just to sort of keep it.
Okay, thank you.
Any other comments or questions?
Just, I would ask that we take up number 7 separately.
Switch.
Number 7, 147 West 29th Street.
So is there a motion to accept all cases except number 7 of 147 West 29th Street? Mr. Schechter, thank you. Do I have a second? Mr. Barrett, thank you.
Mr. Barrett,
Yes.
Mr. Gregory,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
Yes.
Ms. Golden Rivera,
Yes.
Mr. Schechter,
Yes.
Ms. Shelton,
Yes.
7 in favor.
And now to the case that we withheld discussion on, or that we discussed. 147 West 29th Street, is there a motion to accept this case? Ms. Shelton, thank you. Do I have a second? Mr. Schechter, thank you.
Mr. Barrett,
Yes.
Mr. Gregory,
Abstain.
Chairperson Fisher,
Accept?
Mr. Delaney,
No.
Ms. Golden Rivera, Mr. Schechter,
Yes.
Ms. Shelton,
Yes.
That doesn't pass then.
Motion doesn't pass.
four in favor, 1 no, 1 abstain, 2 no.
No, I think you abstained. You said Mr. Barrow, you said pass. Was that it? That was an abstain. So it's 2 abstains.
2 abstain. So 4 in favor, 1 no, and 2 abstain.
Motion doesn't pass. We now come to the master calendar cases. We have 2 decoverage cases and 3 coverage removal cases. The 2 decoverage cases are the same and can be voted on together. They are 57 J Street LLC, 57 J Street Brooklyn, LC 0165, and LC 0167. Ms. Cruz, would you please present these cases?
In 2013, excuse me, the tenants of units 4A and 16 filed for Article 7C coverage pursuant to MDL 2815. In August 22nd of 2014, shortly after acquiring title to the building, the owner filed an amended registration listing units 4A and 16 without prejudice. Approximately a month later, the owner filed applications for decoverage of these units. In separate stipulations, the tenants of units 4A and 16 consented to the law court's granting of the owner's decoverage application in the larger context of a sale of rights pursuant to MDL 28612. Based on the tenant's consent, Judge Addison recommended that the law court grant the coverage applications. There were no hearings conducted. The staff recommends that the board reject the recommendations and amend the application. Section 106I4 of the law court rules requires that an applicant present evidence demonstrating that they're entitled to the relief sought. The owner failed to do so in both of these coverage cases. Because there was no hearing, there was no testimony, there was no documents provided in the record. The record is devoid of any evidence that would support a finding by the law court that the units are not eligible for coverage. The tenant's consent to the granting of the decoverage application alone is inadequate to support a finding by the law court. Further, it is notable that the tenant's consent to the granting of the decoverage applications was in the context of a 28612 sale between the owners and the tenants. The owner's purchase of tenants' Article 7C rights undermines its position that the units are not eligible for Article 7C coverage.
So we're remanding this back for further hearings to determine whether or not to grant the coverage. And the landlord filed 28612 sales records with us for the units.
Well, yes, they did. It was, I don't know if they filed separately, I know that they filed in this case before us.
Right.
Yes.
Okay. That's all.
Anyone else? Do you want to talk about
Yes.
Chairperson Fishman.
Yes.
Mr. Delaney.
Yes.
Ms. Boda Rivera.
Yes.
Mrs. Jackson.
Yes.
Ms. Sullivan.
Yes.
7 in favor.
The last three cases are coverage cases. The first coverage case is Ben Godward and James Pyle, 238 Melrose Street, Brooklyn, TR 1194. Ms. Cruz, would you please present this case?
On March 6, 2014, the occupants of the third and fourth floor units at 238 Melrose Street in Brooklyn filed a joint application seeking Article 7C coverage pursuant to MDL 2815. On August 10th of 2015, the owner and the tenants entered into a stipulation in which the tenants agreed to withdraw their coverage application with prejudice in exchange for the owner to allow the tenants to remain in their units and continue to use the units for residential purposes until September of 2020. On July 21, 2015, shortly before the parties executed the stipulation, the Department of Buildings issued a certificate of occupancy for the building. The certificate shows that on the cellar, first and second floors, is being used for commercial purposes, and the authorized use of the first floor is laundry. Although the parties believe that the certificate of occupancy authorized residential use on the third and fourth floors, it did not. The relevant information to indicate lawful residential use for the third and fourth floors is not on the certificate of occupancy. According to the first page of their certificate, the number of dwelling units in the building is 0. The second page of the certificate shows that the occupancy for the third and fourth floor units is residential, but contains specific information regarding the number of dwelling units on each floor and the relevant use group for the residential use. According to the Department of Buildings audit, the loft use indicated on the third and the fourth floors is not authorized in the zoning district. Further, the underlying DOB alteration application for the certificate was not filed for the purpose for creating dwelling units on the third and the fourth floors. The job description states that the owner seeks to obtain an amended certificate of occupancy for the first floor only. At best, the certificate only authorizes the laundry on the first floor, not the residential use on the third and the fourth floors. Without a certificate of occupancy that authorizes the residential use, tenants' use of the third and fourth floors is illegal. Section 301 of the MDL prohibits occupancy of a multiple dwelling until the issuance of a residential certificate of occupancy. Section 283 of Article 7C provides an exception to Section 301 by permitting residential use in INDs prior to the issuance of the residential certificate of occupancy. But here, the tenants have withdrawn their claim for coverage. Therefore, any residential use in the building is illegal. Because the stipulation perpetuates an illegality and undermines the purpose of the Article 7C, the staff recommends that the proposed settlement be denied and the application be remanded to OAF.
Thank you. Questions or comments about this case? Is there a motion to accept this case? Mr. Schechter, thank you. Do I have a second? Ms. Boda Rivera, thank you.
Mr. Barnard.
Yes.
Mr. Gregory.
Yes.
Chairperson Fishman.
Yes.
Mr. Delaney.
Yes.
Ms. Boda Rivera.
Yes.
Mr. Jackson.
Yes.
Ms. Sullivan.
Yes.
7 in favor.
The second coverage case is Richard Fishina, Lou Weinstock, Xenia de la Cruz, and Maria Teresa Tornenko, 430 Lafayette Street, Rio, TR 1248. Ms. Cruz, would you please present this case?
On March 11, 2014, Mr. Fishina, the occupant of Unit 4L, filed an application seeking coverage for the units on the second and third floors and Units 4L and 5L. Mr. Fishina later amended the application to include the occupants of the third floor unit and Unit 5L as applicants. On September 14, 2014, Ms. Laziak, Mr. Fishina's former girlfriend, filed a separate application with the law court seeking a finding that she is a protected occupant of Unit 4L. On January 16, 2015, Ms. Laziak moved to appear and file an answer in the coverage case. On January 20th, 2015, the tenants and the owner submitted an agreement settling the coverage claims which did not include Ms. Laziak. The agreement allowed tenants to withdraw their coverage applications with prejudice in exchange for the right right to remain in their units while the owner does the legalization work necessary to obtain a residential certificate of occupancy. Prior to the issuance of a residential certificate of occupancy, tenants' residential use of their units is illegal. As I mentioned before, in the prior case, MDL 301 prohibits the occupancy of a multiple dwelling until the issuance of residential C of O. Section 283 of Article 7C provides an exception, but here the tenants do not have this protection because they've agreed to withdraw their claims. The residential use is not protected by Article 7C, nor is it authorized by a certificate of occupancy. Based on the illegality of the residential use, the staff recommends that the board reject the proposed agreement as against public policy and remand the coverage application to oath. Regarding Ms. Laziak's motion, the staff recommends that the board deny the motion, but for different reasons than those stated by Judge Addison in her memorandum decision. Judge Addison found that the motion was untimely. The staff disagrees. Although Ms. Laziak had knowledge of the coverage application, her time to file a motion was never triggered, pursuant to Section 106I of the Law Court Rules. The time to file for vacating a default begins to run from the default notice, not from the default. Here, the default notice was never issued, therefore her motion was timely. Turning to the merits, the staff recommends that the board nevertheless deny the motion. Section 106I2 provides that the party submitting the motion to vacate a default must establish good cause existed for the failure to file an answer. Good cause is defined as a reasonable explanation for failure to file an answer and a summary of a non-frivolous defense to be presented in the case. Ms. Laziak contends in her motion that she failed to appear and answer the initial coverage application because she had not been served. However, while it's true that Mr. Facina failed to serve her, we know that she had actual knowledge of the case by, at the very least, September 2nd of 2014, the date the law court provided her with the copies of the coverage applications pursuant to a FOIA request. Yet at that time, she did not seek to file an answer. Instead, she filed an application seeking protected occupant status for Unit 4L. In her motion, Ms. Laziak offers no reasonable excuse for failing to file an answer in the coverage case after she had actual notice. The staff recommends that the board accept Judge Addison's recommendation to deny the motion.
Thank you. Comments, questions about this case?
So the protected occupancy application filed by Ms. Laziak is still somewhere in process?
No, she withdrew it.
She
She
withdrew.
withdrew it, Lisa.
No.
But she has filed a coverage application, which would be a
You know, if she didn't withdraw, this brings is a very sort of complicated second problem. Here, I don't know whether we've had this before. You know, where two people were legally occupying the space, and then they split up, and then one comes back and says they want it back. We've had a situation like that, do you remember?
Yeah, I think there's one or two. Yeah. So we're sending this back, but we're cutting Ms. Laziak out of this application.
Out of this application.
Right.
She has her own.
She now has her own coverage application for this, for that unit.
Okay.
She withdrew her protected application.
Is there a motion to accept this case? Mr. Barrett, is there a second? Michelle?
Mr. Barrett,
Yes.
Mr. Brewer,
Yes.
Jefferson Bishop,
Yes.
Mr. Delaney,
Yes.
Ms. Walters Rivera,
Yes.
Mr. Shepherd,
Yes.
Ms. Shepherd,
Yes.
7 in favor.
The third coverage case is Matthew Lipson, 475 Kent Avenue, Brooklyn, TR 1262. Ms. Cruz, would you please present this case?
On December 13th of 2010, the occupant of Unit 606 and other occupants of 475 Kent Avenue in Brooklyn filed a joint application seeking coverage for their units pursuant to MDL 2815. The parties settled their claims in a stipulation dated February 3rd of 2012. The tenant of Unit 606 withdrew his coverage application with prejudice because the unit did not meet the 550 square feet eligibility requirement for Article 7C coverage in effect at that time. In order number 4061, the loft board accepted the tenant's withdrawal with prejudice. On January 31 of 2013, the New York State Legislature amended 2815 to, among other things, decrease the minimum size requirement from 550 to 400 square feet. On March 11, 2014, the tenant filed a second application seeking coverage for the unit pursuant to MPL 2815. In a stipulation dated April 10 of 2015, the parties agreed that the eligibility requirements were not in dispute. The application presented a single question of law whether the tenant's prior withdrawal with prejudice precluded him from seeking Article 7C coverage pursuant to the 2013 amendments to Section 2815. The owner argued that the tenant's withdrawal in 2012 precluded his second application for coverage based on the doctrine of res judicata. The tenant argued that the withdrawal with prejudice in the first coverage application did not waive his right to seek coverage pursuant to the 2013 amendments to the loft law. In her report, Judge Miller recommended that the board find that the tenant's application is not barred by res judicata. The staff recommends that the board accept this recommendation. Doctrine of res judicata bars future litigation between the same parties on the same cause of action after there is a final judgment. While the parties are identical, the coverage claims here are not. The 2013 amendments changed the eligibility requirements for Article 7C coverage. The change in the law provided new rights for coverage that did not exist in 2012. As discussed in the proposed order, the Court of Appeals has rejected the res judicata defense when there's been an intervening change in the law that created a change in the statutory rights of parties between the first proceeding and the second proceeding. In each of these cases, the court found that res judicata did not apply because the new claim asserted in the second proceeding was not identical to the claims raised in the first proceeding. The staff recommends that the same reasoning be applied here. The prior withdrawal does not bar a coverage claim based on the change in the law in 2013. There being no dispute that the unit otherwise satisfies the eligibility requirements under 2815, the staff recommends that the application be granted.
Thank you. Comments, questions? Mr. Barrow?
This is, I believe, this mammoth building, 75 10th Street. So I'm curious, with a 400 square foot space, just curious, just want to say this. Why would the landlord want to kick that tenant out? And it's not a question that we can answer, obviously. But it just, it's another instance where I just can't understand the way some landlords go about their business. What is he going to do with that space? Who knows where it is up in that mammoth building? Okay, that's, I just want to say that.
So I just want to say, so they entered into, the person entered into a stipulation voluntarily to withdraw their application with prejudice, and now they're trying to come back, and we should come back and say, well, now, due to the change in the law, we want that stipulation to be now null and void.
No. In 2012, he agreed to withdraw his claim for coverage because his unit was below the 550 mark. In 2013, there's a change in the law. The legislature said the minimum size requirements for an IMB is now 400 square feet. Okay? So in 2014, Mr. Lipson files a coverage application based on the change.
New coverage application.
Completely new, based on the change in 2013. Right. So he's not seeking to have the prior stipulation vacated because those claims are under the old law. He's seeking coverage under the new law, which incorporates the change from 550 to 400. Okay.
Also, it's a good thing that he asked for coverage then, because I think the law went back to 550 square feet, am I correct?
No, we're still at.
We're still at 400.
We're still at 400?
Yeah.
For the next
3.5 years.
And it's,
Oh,
but it's a
okay.
good thing that they lifted the statute of limitations.
No, of course.
Because if they hadn't, then he could have been in a 400 square foot unit that would have been out of law.
Right. Yeah, okay.
Any other comments or questions? Is there a motion to accept this lease? Mr. Delaney, thank you. Do I have a second? Mr. Jackman, thank you.
Mr. Bauer?
Yes.
Mr. Gregory?
Yes.
Ms. Edelman Fisher?
Yes.
Mrs. Lewis?
Yes.
Ms. Golden Rivera?
Yes.
Mrs. Shannon?
Yes.
Ms. Shelby?
Yes.
7 yes.
This will conclude our February 18th, 2016 Loft Board public meeting. Our next public meeting will be here at Spector Hall, 22 Reed Street, first floor, on March 17th, 2016 at 2 p.m. Thank you.
Please hand in your
Hand in your sheets.
sheets. You don't get them.